Hi, I'm Anthony Diosdi. I'm a tax attorney in San Francisco with over 20 years experience in international and domestic tax planning and tax litigation. You can find me at sftaxcounsel.com. Today we're going to be talking about the section 6039 cap F or 3520 penalty. What is this penalty? Why is it so severe? And how does it apply to a lot of taxpayers? Well, if somebody receives a gift from a foreign person and that gift exceeds $100,000 in value, that gift has to be reported to the Internal Revenue Service on a Form 3520, which is reported on Part 4 of Form 3520. There's no tax consequence to receiving a foreign gift, but it still has to be reported to the Internal Revenue Service. Well, although it sounds simple now, the problem is not too long ago, a lot of people didn't know they had to report a foreign gift to the Internal Revenue Service, and neither did their tax return preparers. So, say for example, here in California, where real estate is pretty expensive, you had a lot of people coming in from overseas, either from Europe or from Asia. Their families would always want to help them out purchase real estate or something or some other asset in the US, and they would give their family members a gift. That gift was often over $100,000. That gift was so it was used to buy some type of US property or some type of US asset. No one thought anything about it. Well, a couple years back, when a when someone got a foreign gift, they would talk to their tax return preparer, and then they would discover that the foreign gift wasn't reported on a U.S. tax return on a Form 3520. So they thought that they were doing the right thing, and they would go ahead and amend their tax returns and report the foreign gift to the Internal Revenue Service. Problem was, by doing that, the IRS automatically assessed a significant penalty. So, what is the penalty? Well, the penalty is this: if you don't report a foreign gift on a Form 3520 timely, the IRS can assess a penalty in the amount of 25% of the value of that foreign gift. It starts at 5% per month after the tax return is the due date of that tax return, and it goes to 25%, and after that, you have interest that accrues on it. Now, in the past, what would happen is that the IRS would assess these penalties for not reporting a foreign gift timely through an audit. Well, the IRS was asked to do more with less a number of years ago. So, what the IRS did is that they basically implemented a computer program, and the computer program would look for anybody who filed a 3520 late, and that program would automatically assess that 3520 penalty. To make matters worse, the IRS did a horrible job in training its personnel to abate this penalty. There's a Supreme Court case out there called United States v. Boyle. And what that Supreme Court case says is that if you rely on a tax professional, a CPA or an attorney for a position on a tax return, and that professional messes it up, well, that's a defense. That is something that the IRS should consider in determining whether or not you're liable for that penalty. Well, when the IRS start training its personnel, and this is documented because what happened was somebody went ahead and obtained a Freedom of Information Act request from the IRS, and they asked for the training manuals that was being used to train the IRS revenue officers and IRS collection agents and IRS appeals officers. And what was found is that these IRS personnel were being basically trained that there really isn't a defense to a penalty for not filing a 3520. It's almost like a strict liability type of penalty. And if there's any kind of abatement of this penalty, it should only be used in extraordinary limited circumstances. So that kind of left a perfect storm. So you had people trying to do the right thing, report their foreign gifts to the IRS late when they discovered their error, and then the IRS would just turn around and uphold the penalty. Basically, now hundreds and hundreds of people out there that were assessed this horrible penalty, and what do they do now? So, how do you contest this 3520 penalty if you have this? Well, before we get into that, I just want to say that recently the IRS commissioner announced that they'll be no longer automatically assessing the 3520 penalties for someone that files a Form 3520 late. Rather, what they expect is that if someone files a 3520 late, there should be a reasonable cause statement attached to the letter or to the return, should I say, and the facts and circumstances of the case will be considered and a determination will be made whether or not the 3520 penalty should be assessed or upheld. The problem with that is that the IRS, it's been known that the IRS has not properly trained their staff. So someone goes ahead and files a 3520 late and attaches a reasonable cause statement. The problem is going to be is someone actually really going to give it the fair consideration that it needs? And even if you have a situation where the IRS say they're applying the proper standards upholding a 3520 penalty, you still have out there hundreds and hundreds of people who are already assessed these 3520 penalties, and now they're kind of left out in the lurch, out in the cold of what to do about it because the IRS was so strict with these penalties and so strict and not waiving these penalties. So let's first start with what the defenses are to these penalties. Then we'll talk about potential ways to contest the penalties. And then we'll talk about potential litigation. So the law, here's what the law says, as I indicated when we first started this discussion. The law says if you rely on a tax professional, a lawyer or a CPA or a tax professional, which is an enrolled agent or a registered return preparer, to prepare your tax returns, and you provide all the information to the tax professional, and the tax professional doesn't report your foreign gift on the Form 3520, that's a defense. So that is one defense. Now, another defense is if the IRS assesses a penalty, like a 3520 penalty, you're supposed to get a manager to sign off on that penalty. All right, that sounds simple enough, but remember what I said. I said that the IRS is automatically assessing these penalties through a computer program. So if you have a computer program assessing these penalties, that begs the question of how do you actually have a manager signing off on that? So if you're assessed that penalty, what should be done is an administrative record should be pulled from the IRS to determine if the IRS complied with that requirement. Now, the third defense to this penalty, which is a little bit more interesting, when Congress enacted this penalty, this 3520 penalty or Section 6039 Cap F penalty, it's unclear whether Congress actually authorized the IRS to go ahead and assess this penalty and collect this penalty from individuals. A very compelling argument can be made that the IRS can only go ahead and flag the penalty and then refer it to the United States Department of Justice, and it'll be up to the United States Department of Justice to go ahead, file suit in a United States District Court, assess the penalty, and collect it that way. So this area law has not been settled yet, and there's a close cousin to the 3520 penalty, and that's a penalty for failure to file a Form 5471. And in that case, the tax court wound up and held that the IRS does not have the authority to go ahead and assess that penalty. The IRS can only refer that assessment of that penalty to the Department of Justice, and the Department of Justice has to go ahead and sue to collect that penalty. So the verbiage is somewhat similar. It's not identical, but it's somewhat similar between the Form 5471 penalty and the 3520 penalty. So an argument a compelling argument can be made that the IRS doesn't even have the authority to go ahead and assess and collect this penalty. And it's an abuse of discretion for the IRS to try to collect and assess this penalty. Now, your fourth argument is under the Eighth Amendment of the Constitution. What the Eighth Amendment says is that individuals should not be assessed a penalty that's disproportionate to the violation. So a lot of these 3520 penalties, you're talking about penalties in hundreds of thousands of dollars and sometimes even in millions of dollars for just not filing a simple form that doesn't even have a tax consequence. So that begs the question whether an Eighth Amendment argument can come into play here, because it's just a simple form that wasn't filed, and does that warrant a huge penalty, a huge monetary penalty? And probably your last defense to this would be the Seventh Amendment. And what the Seventh Amendment says is that in a federal court, if there is a penalty assessed by the government, that individual has a right to a jury trial before a district court. So, and if the penalty is over an amount of $25, unclear whether or not the Seventh Amendment argument can apply to this, but nonetheless, it should be raised. So you have quite a few arguments to contest this 3520 penalty. So now, since we know what the defenses are, what do you do? All right. Well, the first thing to do is write the IRS. Write the IRS, write appeals, try to convince appeals to go ahead and remove that penalty. The problem is, like anything else, it depends on who the individual is. Sometimes you'll get a reasonable person in the IRS who would consider this and might remove the penalty. Other times, you're going to get someone who's not properly trained, or you're going to get somebody who just doesn't care and would just uphold the penalty. You are trying to resolve the penalty within the IRS, and you're getting yourself a difficult agent. Do whatever is necessary to go over that agent's head. Go to the taxpayer advocate's office. Go to that agent's manager. Keep writing as much as possible and to as many people as possible with the arguments that I mentioned to try to remove that penalty. Now, another way of trying to contest a penalty is going to court. All right. Probably the easiest way of doing it is going to tax court. Now, when the IRS assesses a 3520 penalty, they're going to give you a notice. Now, if a long period of time draws on, then what will wind up happening is the IRS will issue a final notice of intent to levy, and that will allow you to have a collection due process hearing with the Internal Revenue Service. And you can try to contest that penalty through that collection due process hearing. At the end of the collection due process hearing, if the IRS doesn't remove that penalty and you don't come to a resolution with the IRS has to issue to you a notice of determination. Once you get that notice of determination, you have 30 days to petition the United States Tax Court. And you could try to contest it there with the arguments that I mentioned earlier. Now, I've litigated quite a few cases regarding the 3520 penalty in tax court. And this is just my experience. My experience is that the tax court really doesn't want to hear these type of cases. And they push the IRS counsel hard to settle these type of cases. So if it's at all possible to get into tax court, that is a really good way to try to resolve the case. The problem is that the IRS understands this. The IRS knows that if it goes to tax court, or if it's forced to go to tax court, they're going to be before judges that are going to be unfriendly to their position. So what they are doing, this is in my experience anyway, and I handle quite a few clients with 3520 penalties, is that the IRS is just assessing the penalties and not issuing that final notice of intent to levy. They are not giving taxpayers the opportunity to go to tax court. So what they do, they assess the penalty, they let it sit out there, they rob people of their tax refunds, they may attach someone's Social Security benefits or other government benefits, but they'll just keep doing that as long as the statute of limitations will run, which is typically 10 years from the date of the assessment. So, What do you do if you're in that situation? If you're in that situation where you've tried everything with the IRS is not giving you uh, their their fair shake, should I say, in the administrative appeal process, and they're not allowing you to go to tax court, well, then you have one of two options. First option is if you have the funds available, pay it in full, and then sue them in either a United States District Court or a United States Court of Federal Claims and argue those potential defenses that I mentioned earlier. And those defenses are reasonable costs, IRS, whether or not you had a manager sign off on the penalty. Should be argued that the IRS doesn't have the authority to assess the penalty. Eighth Amendment and Seventh Amendment. That could be raised in a refund litigation type of a suit. You're probably better off taking it in the United States District Court rather than a Court of Federal Claims because the United States District Court has the ability to order the IRS to do something. Like they can order them to remove the penalty. Now, or they can order the IRS to remove the penalty based upon the fact that they abused their discretion and assessed the penalty that they didn't have the authority to assess. What happens if you don't have that money to pay that penalty in full? And you can't go to tax court and you are basically stuck in a situation where the IRS is not doing anything administratively. You've now went to the appeals officer's manager, who you tried to get to remove the penalty. You went to taxpayer advocate. They didn't do anything, and the penalty itself is really, really large. There is one other possibility, and that possibility is to try to sue the IRS in a district court under the Administrative Procedure Act, which is the acronyms of the APA. And you could say that you didn't get your fair hearing before the IRS. And even if you had a hearing, the IRS, at least in my experience, they're not giving proper notices. The notice itself should state why there's a denial for the removal of that penalty. And the IRS, let's just say the IRS didn't give you that proper notice, then you could go ahead potentially go to the district court and you can ask the district court potentially to order the IRS to grant you another hearing, another administrative hearing where your arguments would be heard. This is something new. I mean, there isn't a heck of a lot of case law on it, but I can tell you that there is cases right now, at least one case that is pending before the district court in this area. So, if you do have a 3520 penalty, it is assessed against you. It's really, really important to seek out an attorney who understands this area of law well, and who can kind of help you to contest this penalty either administratively before the tax court or before the United States District Court, depending on where you are along the process. Now, as always, this is not meant to be advice that can be relied upon. This is not tax advice. This is not legal advice. Seek the advice of a tax professional if you've been assessed the 3520 penalty or if you have questions about it and you want to see what you can do about trying to get that penalty removed.